Okay, we're here. All right, everyone. Welcome back from lunch. I'm John Dickerson. This is the third and final session, which we've retooled slightly based on earlier sessions. It's now entitled John Rawls, A Life Reconsidered. The funny thing about him is he apparently was, he was like, he hated the limelight. So the idea that his name is being bandied about here is, I think, is a hopeful sign that ideas live on, even if you're not running in front of the cameras all the time. So today's session will be about kind of the balance in presidential power, the shape of emergency powers, why they're necessary, vital to the job, but also how they can go wrong, both when you are a hero in error as a president or when you are a wannabe a demagogue. And my hope is that we can do brief remarks as I go down the table and then engage in the kind of conversation both at the table and from the back benches that we enjoyed in the previous session. So, Sai, I'll start with you. Your essay in the book is about the kind of sloppiness of the grants of emergency authority to presidents. Give us a sense of the of your argument, and then what are the stakes there with these emergency powers that go on forever, and what do you think realistically can be done?
Well, it's great, again, to be here, and thanks for the Miller Center for putting this on. I think, at least some of the answers to these difficult problems can be found in the past, because we've had emergencies before, and we've had to pass legislation, both ex ante and ex post legislation, to deal with it. And so we can go back to the Revolutionary War. Congress wasn't always in session, and from time to time it would give authority to George Washington to detain people indefinitely, to try them before military courts, to seize supplies. And what they would do is they would say, you can do this for 60 days after we meet, and then obviously if we think you need to continue to have this authority, we'll give it to you again. But there's no reason for you to have these kinds of super consequential, truly emergency powers forever. We're going to give them to you in a sort of limited duration. After the Constitution's drafted in the first or second Congress, they pass a Militia Act that authorizes the president to summon the militia. When the laws can't be executed by the ordinary civil means, the president has authority to call forth the militias, but he needs a judge to certify that the laws can't be faithfully executed by the ordinary civil means. And so there's a check there, right? And so there are answers in the past that we could draw upon. I want to contrast, I think, two modern situations, which I think, to my mind, are kind of silly. Donald Trump gets $1 billion from Nancy Pelosi to build a border wall the same day he declares an emergency and transfers $5 billion of funds to build a larger border wall. You could think there's an emergency at the border, but you can also suspect that Congress has decided it'll be $1 billion and not $6 billion. And then I think, President Biden's student loan forgiveness, I think, I like to tease my students. He gave the loan forgiveness under the HEROES Act, and I say, you guys are all heroes. I just think, it's a political move to help him with his base, and I don't begrudge it, the political nature of it, but it's just not an emergency. So what I would suggest is a couple of reforms. I think maybe we can build in checks that some third party, maybe the courts, maybe some other institutions, can decide whether there actually is an emergency. I think we can do perhaps a better job of defining what is or is not an emergency. And then I think finally, there's no reason why emergencies ought to last forever. If something lasts forever, it's not an emergency, and the legislation shouldn't be triggered by an emergency, right? It should just be ratified under ordinary law. If it's really truly emergency, give them 60 or 90 days after, the measure will take effect when the president says it will, and then it will last 60 or 90 days after Congress reconvenes. And of course, if Congress never reconvenes, the authority would continue indefinitely. I think that solves the problem of truly emergency situations and leaves the authority with the institution that should properly exercise it, Congress. And as we learned yesterday from Professor Lee, Congress has shown an ability to act in emergencies over and over and over again. Sometimes you might think they've perhaps done too much, but they certainly haven't shown an inability to legislate in the face of an emergency. So that's my suggestion.
Excellent. Thank you, Cy. Now we're going to go to Bob Bauer, who is with us via electronic communication. And he
Hi.
will appear hopefully
Hi,
soon.
John.
There you are. Hello, Bob.
Hi, how are you?
We're fine. We're going to, I'm not hearing you very well at the moment, so we're going to try and address that, and I'll just talk for a second. So, Bob, you've written about transparency. You've housed a lot of solutions to presidential overreach in the idea of transparency, so I'd love it if you would outline that idea, and then if you could just sort of walk through how that would work. I mean, who's going to make the president more transparent? And then finally, what happens when you set up a system of transparency and you get a president who has no interest in being transparent at all? And hopefully, now the audio has hopefully been fixed.
Okay, am I clearer now?
I think maybe if we can get it turned up a little bit, but I can hear you.
Okay. Well, let me know, and if I have to raise the decibel level, I certainly will do that. The paper just stresses transparency as a mechanism for addressing abuses of presidential power that could potentially be more effective as a ground of compromise than major struggles over Article II authority, just substantive struggles. The whole question of transparency, or the whole utility of transparency, being flushing out into the open for public debate, public pressure, the participation of civil society from any direction whatsoever, flushing open presidential actions and forcing some degree of accountability that permits constraints then to be developed and to apply. And of course, we know that there have been, for example, some less controversial collapses of transparency requirements or transparency norms in the last several years that may well need to be shored up by legislation. A good example being production by presidential candidates of their tax returns, which operated by norm for a long time, and then certainly that norm is in question now. But I just wanted to concentrate on just one example of how transparency would work very briefly in the context of emergencies. And the emergency statutes that I would like to refer to here are of a particular kind. That is the Insurrection Act, that authorizes the president in some cases to quell insurrections, rebellions, whatever, to enforce federal law, to deploy militias or the armed forces in particular states, sometimes on the president's own determination that such an insurrection, rebellion, whatever has occurred and the use of force is required, and sometimes at the request of states, different statutes covering different circumstances. And in the book that Jack Goldsmith and I wrote, we strongly suggest that this Insurrection Act needs to be reformed. You might remember that at least one senior Trump administration official suggested using the Insurrection Act as a backup if people protested measures that were being recommended for him to overturn the outcome of the election. Somebody said to that senior official, there could be riots in the street, and that official responded by saying, well, that's why we have an Insurrection Act. So you would have people protesting Donald Trump's efforts to overturn the election, and then Donald Trump being advised to use troops to stop the protests. So it seems like it's a timely concern. These statutes are old. Some of the language certainly needs to be reformed. But on the transparency front, and just on the transparency front, there are all sorts of transparency measures that would force the president by law to be accountable, and I think in a way that is purely constitutional, to the Congress for the exercise of this Insurrection Act authority. If the president's responding, for example, to a request from states, theoretically responding to a request from states, and Congress would require details about the consultation that the president engaged in with the states, the requests that the states made. If the president acts on their own authority, Congress can require reporting to the Congress on the nature of the threat, the projected use of force, the limits that the president has taken to address the problem by means other than the use of force, and flushing out any state or local concerns that were communicated to the executive branch about the use of force. And there are ways to build these reporting requirements into whatever duration is permitted for the use of presidential authority. So this would require then this information to become public, and for Congress to have the ability to intervene if it's not satisfied with the president's responses, and frankly for other actors in the political space to put pressure on Congress and pressure on the administration in the event that these statutes are being abused in the name of an emergency, rebellion, insurrection, unlawful combination, some of the language that appears in the Insurrection Act. So that's an example of the kind of reform that uses transparency to address these issues, that skirts some of the more complicated, likely more involved conversations that would take place over substantive reforms to define, for example, terms like insurrection, assemblage, unlawful combination.
Excellent. I think one of the things that interests me is whether Congress really wants to intervene sometimes in some of these thorny questions, but we'll leave that for a moment. Eric and Alan, let's talk now about the use of these emergency powers. Eric, I'll start with you. Are the emergency powers that the president has sufficient to the kinds of emergencies that an administration faces? If not, where should they be improved? And how much should a president or administration rely on its own restraint in maintaining a larger view about the separation of powers, or is that not their concern? They got to just deal with the emergency and let other people stop them.
Well, John, I started the panel I was on yesterday with a confession, so I think I need to do the same today. And my confession today was really sparked by the comments from Don Baer and Barbara Comstock in the earlier panel when they reflected on American political history changing partisan alliances. I started life as a Democrat. I grew up in a family in New York City where I was taught that if you voted Republican, if you pulled the lever for Republican, which shows you how old I am, that your hand would wither, and I became a Republican under Ronald Reagan, but I have now decided, thanks to Don Baer, I am a Whig.
Yes, Tippecanoe and Tyler too. Go ahead.
So, we spoke yesterday, in an earlier panel. I think the president's authorities to deal with a national security emergency don't need to be augmented. I'm concerned, really, particularly in the current moment, that there's more of a desire to try and constrain them. And while I'm not a lawyer, and I'm not going to play one on TV here, and I don't want to engender a debate about the unitary presidency, but in the current moment, I understand the desire to end our endless wars and the discussion about revising or revoking the AUMFs. But, in the light of the president's speech last night, and the fact that I think we're at a particularly perilous moment in international affairs, I know Philip may agree with that. I know his and my former boss, Bob Gates, has just said that we're facing the most serious, complex national security set of crises since the end of the Second World War. I agree with that. We've got the major land war in Europe, biggest land war in Europe since 1945. We're perhaps on the cusp of a regional war in the Middle East. We still have 2,500 troops in Iraq and Syria, and Monday will be the 40th anniversary of the bombing of the Marine Corps barracks by Hezbollah, which before 9/11 killed more Americans than any other terrorist group. It hits me very much personally. I was the person who had to wake up then Secretary of State George Shultz in the middle of the night, tell him what had happened, former Marine. So given that set of facts, and given the auto-da-fe that is the Republican conference in the House of Representatives, it strikes me that it is the wrong time and the wrong place to be having a debate about the president's authorities to respond to conflict, given the high chance that he may have to use those powers in order to defend our forces abroad and the United States of America at home. And before I yield back, I would like to reserve time later, if I could, John, to amend my earlier confession. Because I started out by saying I was a creature of the deep state. It was meant to be a sarcastic comment. But in light of Sarah Wilson's comments yesterday, it's actually a Turkish import into the United States. And as a former U.S. ambassador to Turkey, I have, I think, special authority to speak about the deep state, and I'd like to come back to that.
The gentleman is recognized. But now that you're reserving your time, it sounds like you're more of a creature of Congress than of the deep state. So you'll have to work that out with your confessor. Alan, pick up on this idea of the emergency powers of the presidency, where they are in the correct balance, but then also Eric makes the very strong case for the current national security environment, which is so perilous, and Bob Gates writes about the fact that because the rest of the American institutions of government are in collapse, it makes America less safe. On the other hand, these also sound like the arguments that would be very useful for somebody who wanted to use the chaos of the moment to promise order and use all of these emergency powers to do willy-nilly as they pleased, which may or may not be in the national interest.
Sure. So, like so many people have done before me in the last day and a half, and people in both Congress and the executive branch, I'm going to redirect your question just slightly. Because, I think the issue here is it's not so much executive powers, but it was the other side of Sai's essay about the nature of constraints. And I think that the overarching theme of our conference so far has been, we've seen this, we've observed a series of undesirable outcomes over the last year, 5 years, but particularly the last 6 or 7 years, and this has created demand for increased constraints on the executive in particular. The American people essentially have elected in the recent past someone that many of us may find anathema. And so the solution to that is to impose greater constraints on the executive branch in general and the executive in particular. So from a historical observation, this need for constraints is not new. The founding fathers were acutely aware or concerned about unlimited executive power in King George and in the monarchic system in England and in Europe. So those concerns, they're just as valid today. The power and authority of the executive branch as one of the three co-equals of government, but also the authority and power invested in the president as an individual is far greater today. But at the same time, so too are the constraints that individual faces. And these are multiple levels and layers. So we don't live today in, Jefferson's world where Jefferson empowered Commodore Barron to go to Tripoli, and he was authorized, if he saw fit, Commodore Barron that was, to invade Tripoli with an overland army invasion to install a new leader of Tripoli. The president today is constrained by international law. So as was remarked yesterday, it wasn't until 1927 in the Kellogg-Briand Pact that invading another country was against the law. The powers of the president in the waging and the way that war is waged today has been highly constrained after World War II in particular. After 1973, the War Powers Act comes into effect, and obviously it's highly contested by both Congress and the executive branch, what kind of constraint that actually is. The courts have been loath to weigh in on that in particular, but also in national security grounds. Politics is a significant strain on the president and the executive branch. Congress does, the way we fund our defense sort of industrial complex, both the private sector as well as the military, the annual defense appropriation doesn't really include the funds for ongoing operations, as we see in Ukraine, for example. And so that Congress continues to play an extraordinary role in anything that we would think of in the use of force in ongoing operations. The current debates over, for instance, renewal of the 702 authorities in the FISA system reflect great concerns here. So here's an example. So today, the United States could not defeat Japan or Germany as we did in World War II. And many people, many of us, myself included, look back on those military victories, not just as military victories, but as political victories, where following the military defeat of Japan and Germany, two of the greatest powers in the system, it was also a political defeat that enabled the United States and its allies to reform not just their governments, but their societies as a whole. Well, we could never do that today. And it's not a capabilities issue. The United States military, for example, has capabilities far in excess of what we had in World War II, setting aside the 14 million people under arms. The differences are the constraints. The strategic bombing campaign is simply off the table. The means by which we prosecuted the military defeat in Western Europe, if you study closely the behavior of American soldiers, huge fractions of them would be brought up on charges today. For the most part, I think the rules are there. Compliance lies in enforcement, and oftentimes, we're surprised that the executive or the executive branch doesn't want to enforce or compliance on itself, but if you've ever worked in athletics in a university, you find that that's not surprising. The second area, though, is leadership. What's that? Not this university. I could take the fifth on that one. So, leadership. So I'll give you another university example. At the University of Michigan about 20 years ago, there had been a series of unfortunate administrative events, and the then president, Mary Sue Coleman, pulled together a meeting of all the senior administrative staff, and she said, here's what we're going to do. Not only are all of you going to have to declare any conflict of interest you have, you're going to have to eliminate it. But not only are you going to have to eliminate your conflicts of interest, you're going to have to declare and eliminate all appearances of conflicts of interest. And you don't get to be the judge of the appearance. And so that policy was in place. It was a small c constitutional change. It was not a large c constitutional change in the operation of the university. After she was no longer president, the norm, the informal rule faded, and as people follow that university, they've found themselves in a number of untoward events since then. When leadership, and I think we can all think of the leader I'm about to talk about, conveys the view that compliance is for suckers, compliance suffers. It's a leadership issue. It's not an enforcement issue. It's not a compliance issue. It's not an emergency powers issue. It's a leadership pathology. Now, we can't legislate good behavior. We can try. I think all of us around this particular table and sitting in the room at one time or another have either tried to be party to or have been the target of people trying to legislate better or different behavior, and it rarely works out well. I think I just close on an observation about Dan Meyer's point that leaders reflect their constituents' preferences and expectations. And when we're not getting the leadership that we feel we need, or that feels with the need to constrain it, to limit their emergency powers, even in the anticipation of extraordinary emergencies that are potentially right down the pike, I think more oftentimes we should look inwardly about who are the constituents that are, in a sense, creating these problems that we find so difficult to deal with. Thanks.
Thank you, Alan. As you were talking about the constraints on the presidency from the war-making perspective, I was struck, though, or reminded, of course, that General Milley, at the direction of the Secretary of Defense, gets on the phone with the Chinese because he's afraid the president's going to use his war-making ability to get into a conflict to stay in power. So at least the chairman of the Joint Chiefs of Staff didn't think he was sufficiently constrained to keep from making those phone calls. Phil, where do you come down on this question?
Well, people who actually work on emergencies tend very quickly to get down to cases. So before I offer generalizations about emergencies, let me tick off 3 cases that have all happened in the last 3 years. I think you'll agree these are not trivial cases. Case 1 is the COVID emergency, which was both a global and nationwide emergency, arguably on the largest scale since World War II, and in which we had the enormous challenges of nationwide emergency management and management of the nation's pharmaceutical industrial base. Case 2 would be Lend-Lease today and the defense industrial base. So as Eric pointed out, we're now in a potential pre-war condition. I don't think that observation has fully sunk in for a lot of people, but we are. I'm not being alarmist. I think it's not a hard statement to defend. And so there are a variety of emergency issues that have already risen and have been risen now for nearly 2 years. Third, AI, which if at least many qualified people are right, raises an imminent potential of extreme risk to societies. The British government has invited me to participate in the AI Global Safety Summit they're hosting on November 1st and 2nd at Bletchley Park. So I've been hanging around very smart people about this subject, and I'll tell you they disagree about the level of risk, but very smart people are very concerned. Some are less concerned about right now, but a lot of them are very concerned about the next year or two, which is pretty soon. So you pick those three cases, and everyone here has some knowledge and experience of all of them. And I think if you reflect on those three cases, you could make at least a few tentative generalizations about them. First is in all three cases, the ex-ante authorities are actually relatively weak. In the COVID case, we tested our limits of emergency authority in the vaccine mandates. The courts kind of split the difference in a relatively sensible way, I think, actually, on the vaccine mandates issue. But on the great issues of national emergency management and how to mobilize the pharmaceutical industrial base, we did a very poor job at first. People think the CDC is a national public health agency. It is not. We still have the fundamental national public health system that we created in the Grover Cleveland administration. And almost all operational and executive authority are scattered among thousands of state and local, territorial, and tribal entities. And that continues to be the case actually today, and it showed. And ultimately, even in the desperate expedient of warp speed, then had to turn to the Department of Defense after the palpable failure of all the national health institutions, including HHS. So ex-ante authority is relatively weak in that case for sure, and then we could comment on Lend-Lease and AI. They're also very, very weak. Private sector is far ahead of governance on this. A second generalization one could make is that ex-ante operational capabilities are relatively weak, though in the Lend-Lease and defense industrial base case, I think that's a mixed story in which there were some strong ex-ante capabilities at the very high executive levels and operational coordination in Europe. But the capabilities to actually mobilize the defense industrial base have turned out to be weak, and that is still basically running in a peacetime mode, and it shows. And it's had very large effects already, which may get worse. And the operational capabilities in the government to do, say, model evaluations on potentially dangerous AI is almost non-existent, actually. The work that's being done now on those evals, government is basically asking the private sector to do it, and then hoping that companies will come up with good best practices that the government can at least say that that's good. So that's the second generalization. A third generalization is that Congress actually does work after the shock. And it works pretty well until the shock wears off. So that's not necessarily the locus where the failures were that usually is that the executive didn't have an intelligent idea of what to ask Congress to do and didn't have coherent policy designs, because Congress is willing to enact for a while kind of basically anything that was put in front of them. And then a final point is that in all three cases, the key source of emergency authority that's most relevant was the Defense Production Act. The Defense Production Act, which actually no one here has mentioned so far. This was an act passed in 1950 when the United States was deciding that it needed to get ready to wage World War III. And it got ready to wage World War III really fast, and then the act has stayed on the book. I've done some work involving the DPA and on all three of these cases, and people are straining to figure out how to get the DPA to work effectively. In the first case, the COVID case, they finally did actually get the DPA to work reasonably effectively in the context of warp speed. Actually, Pfizer opted out of it at first, and then more or less was forced to go in under the DPA at the end of 2020 when it realized it couldn't get the supply chain it wanted unless it accepted the DPA's strictures. But in that case, it worked. We're straining to use the DPA in the Lend-Lease defense industrial base problem for a variety of reasons, including just sheer political will. And in the AI case, people have actually not even begun to explore how it could be used in that case, and I've been trying to do some work on that. But my point, notice that what I've evoked now is an emergency power that actually is like a pre-war, war readiness emergency power. A power that was meant to be used to help the president mobilize the economy. And I think actually, rather than talking about our counterterrorism authorities or FISA authorities, which is a subject I used to dwell on many years ago, I think sadly this is a subject that needs our attention now.
Thank you, Phil. Fran and Mara, when Alan was listing all of the constraints on the national security response the president can have, I've thought of you two, because when you have to actually engage in trying to protect the country, having to deal with all of the constraints it must drive you nuts. So can you both explain, just from the day to day, what these constraints feel like, or you all can do as everyone else is and answer an entirely different question. Mara, go ahead.
So I said to myself, why are they having me on this panel? And I thought, well, because it was your job to deal with emergencies. And as it turned out, both on the counterterrorism side, it was both international and domestic, and on the homeland side, it was obviously domestic. I agree with Eric. I think on the national security side, we had particularly strong authorities that it's like muscle memory, right? We've had regrettably enough practice at them that they're up to the task. The other thing I think people fail to think of when they think of emergency powers is that oftentimes the president he has the ability to rely on the organic authorities of the agencies themselves. He doesn't need to reserve a power to himself. He can direct the Secretary of Defense or direct the Secretary of Homeland Security to use their own authorities. Here's where I think where I'd like to focus the conversation for a moment is how this plays itself out here at home. Because I think that's the place we've heard a lot of discussion over the last few days about Americans losing faith in the competence of government, the weakening of the institutions, and it's in a domestic crisis, that's where the government and the individual sort of collide. And I'll give you two examples. One very easy, very quick. Josh remembers the many phone calls from me. As you all know, when there's a fire, a flood, a hurricane, the first thing the states want is an emergency declaration. It gives them funding. It's quite transparent because, believe me, and there are political constraints here, because if the president does not act quickly enough, you believe politics comes into play, and Congress will get involved, and the governors are involved. And so this is a place where the release of those funds allow the government to serve the individual at its darkest moment. You're without a home, you're without communications. And that has typically, across administrations, Republican and Democrat, I've worked for both, has worked pretty flawlessly. And it's become, it's never, in my experience, been played politics with. Because again, it goes to serving your constituency at an individual level, and that's in everybody's interest, no matter what party you're in. I'd like to now talk for just a moment about something that Bob raised, and that's the Insurrection Act. I think folks don't remember this who were not directly involved. This came up in the context of Hurricane Katrina. Normally, right, I used to say, if you have an emergency and you're waiting for the federal government to show up, you're in a world of hurt, because the people who are going to serve you best are the people closest to you at the state and local level. In the instance of Hurricane Katrina, We were quite careful in the White House not to say this at the time, but state and local government dissolved. It was not capable of serving its citizens. As you'll recall, the New Orleans Police Department disappeared. They were absent because themselves and their families were affected. And so the president was confronted with, did he need to trigger the Insurrection Act so that the federal government had authority to take over the response at the local level? This is, Andy Card was chief of staff, Josh was over at OMB. Josh is at OMB, and so there's lots of money involved here and consideration. And there were real debates among the president's advisors about whether or not, and the implications of doing this well beyond that single event, because it really implicates our whole federal system, right? The judgment at the time, based on the advice the president got, was not to implement the Insurrection Act. Not least of all, you talk about political constraints. The president's brother, who was the governor of Florida at the time, literally walked out to an impromptu press conference and said how strongly against the president invoking the Insurrection Act. It wasn't invoked there. It had implications in terms of the speed with which we were able to serve the citizens of New Orleans. And I can tell you, when the president charged me to go back and look at lessons learned, he has long wondered if he shouldn't, despite the negative politics for him and others, it would have certainly negatively impacted the governor and the mayor of New Orleans, whether or not he should have done it anyway, because of the impact on the individual. Having now explained this, the import of the Insurrection Act, I could not agree more with Bob. The importance of us understanding when and why we will ever use that. Because it strikes at the heart of a federalist system. You don't want an executive who may, for his own reasons, decide to implement it. I think there's not a whole lot of law built up around this or experience. And as a result, I think there needs to be a very transparent and common understanding of when and how and why we will ever use the Insurrection Act, because I think it has also real long-term implications for the legal structure and how we run the country.
Thanks, John. I want to come at your question from not just the executive branch perspective, but the legislative branch, because I had the privilege of working early in my career as the chief counsel at the House Foreign Affairs Committee for Lee Hamilton, who was, I see a lot of nods around the table, the single best teacher I could have in how Washington is meant to function and how the country is meant to function. And so I went from that role to legislative affairs at the National Security Council and ultimately chief of staff there, with some back and forth with the Hill. So the training I had from Lee early on, when he had a lot of staff debating the different politics of getting to X, Y, or Z, was let's figure out what the right thing to do is, and then let's figure out the pathway to getting there. Managing, not being oblivious to what the politics were, knowing there's always going to be politics, but set your sights on the horizon for the right thing to do, and then figure out the pathway. And I saw a lot of people do that on Capitol Hill, as well as in the executive branch in both the Clinton and the Obama administrations. And so I am less about what particular piece of legislation does X or Y, and more how do you get the right group of stakeholders around the table. You heard both Louisa and Dan answer very clearly in the earlier panel that there's a majority of members of Congress who support the definition to me of what the right thing is to do, who believe in the institutions, even if they're not the loudest voices. And often those people are not the loudest voices. You get to figure out, and you get a lot more done behind the scenes than with people in front of cameras all the time. So to me, you've got to figure out, and I thought Phil's 3 examples are very telling on a few points, because they're all issues where there is no line between domestic and international. And particularly now, as we're approaching the kinds of challenges we have in the world, I think that's an opportunity. Making our economy stronger, showing that we're delivering, that government can deliver for people, and doing it in real tangible terms, as someone on the earlier panel said, that the Defense Production Act can help that in a variety of ways. Eric had said yesterday, talked about the need of a whole of society approach. It's the same things. We don't divide between domestic and international. There's really not clear lines between what government does and where the American people are. And I think some of the ways to address the polarization challenges we have, they are very real, but is to show how government can make a difference, how there are a lot of people who care. You bring them together around specific issues of concern, whether it's pandemic response, whether it's safe and secure digital architecture, which would be my translation of some of the AI work, whether it's, and this is a harder one, on the industrial base. It's harder for people to feel the need, how putting money, for example, into defense and into private industry is actually critical for their ability to be secure day to day. I actually think President Biden's speech last night was an attempt to do some of that, to do some of the translation. But to me, the answers lie, and my experience has been, in getting the right groups of people together around virtual or real tables who come from a diversity of places and a diversity of thoughts and a diversity of experiences, who find the commonality in what they're trying to achieve. And I've seen it work, so I don't think it's idealistic, but it's very much like you gotta slice away to get to the right thing to do, to get to that point on the horizon.
Just quickly, the slice away part, though, meaning you have to slice away with all the other dysfunction that's been the subject of all the other panels, to get the convening people at the table who have the right viewpoint and can get things done.
I guess what I mean by slice away is, Louisa was mentioning this in another conversation, not at the table yesterday, was hitting singles and doubles. And I say this, and my brothers would be quick to say I am not a sports fan, so I'm going to quickly get into trouble if people move it further. But you build the wins steadily to get to the place where you have the political alignment to make the bigger structural changes. And you keep your eyes on that horizon. At the same time, you know what steps are going to build your kind of staircase to it.
All right, Sally and Judge Ludig, we're talking here, the age-old question of presidential emergency power and who constrains it is of the moment, not just because it's always been of the moment in American government, but because of the last president we had. So, Sally, can you give me your sense of, well, obviously your firsthand experience, but also, these larger questions of the balance and who constrains a president, but also what was exposed by the last president, who may very well be the president again, and how we should think about constraints on executive power in an emergency when you've got somebody who will just declare an emergency.
Right. Well, I was thinking about Bob's comments about transparency as a measure to hold the president accountable and also to act as a chilling effect, essentially, for bad behavior. And I think that certainly is an important element, not just because of the chilling effect, but also because I think the transparency builds trust, the public's trust in what their president is doing. I actually, Griffin Bell, when he was Attorney General, used transparency to try to chill some of the conduct that President Trump was involved in. He has since said that he would publish on a daily basis a log of all of the calls that he received and all of the people who came to see him, because he was getting calls from the Hill and otherwise on criminal matters that were just out of bounds, and thought, if I shine some light on this, maybe that'll, and it worked for him. But I think what we saw in the last administration is that shining light on it doesn't always work, because what was happening there with respect to DOJ, and look, my prism on the executive branches all through the Department of Justice, which I think is a unique agency of the government, but he's doing it right out loud and right in front of everybody. He's tweeting that you should be, initiating an investigation of Hillary Clinton, or, directing, although not officially directing, his Attorney General to take certain actions. So here, transparency wouldn't be enough. because just because everybody knows he's doing it, it still undermines the rule of law if the Department of Justice acts on that. And even if they don't, it undermines the public's confidence that the department is acting with the type of independence that's absolutely necessary. I've already forgotten what your question was.
Oh,
and so
that's all right. That's all right. That puts you in good company
stalling
with
right now.
everyone else. At least you admitted it. Everybody else is just. Well, I'll reframe it slightly, which is so. Since this is supposed to be a reform-minded conversation. It seems to me one of the tensions is what reform would be necessary, but then also the reforms can constrain faithfully acting presidents in an incredibly harmful way in the world that Eric described.
Yeah, I worry about that a lot. I mean, I know that there was a big push when people seemed shocked that this wall between the White House and the Department of Justice is a norm and not really a rule. But I have to tell you, I worry about making it a rule or a law, and for this reason. While 99.99% of the time, there should be absolutely no interaction between the White House and DOJ on specific criminal cases, or civil cases for that matter. Not where, of course, DOJ is defending the administration, but otherwise. While the vast majority of the time that shouldn't happen, there are the rare exceptions when, for example, there may be a national security issue that is implicated by a particular criminal action. There can be an exchange of hostages that takes place. I mean, DOJ hates that, but it can happen sometimes. There can always be the very unique situation where there might need to be some type of communication between the president and the attorney general about a criminal matter. And so I would hate for there to be an absolute rule that can never occur. And I also worry a little bit about legislating to Donald Trump. I mean, frankly, I don't think we can imagine every possible way that a president like Donald Trump could abuse his interaction with the Department of Justice. And it's a bit of folly, I think, to try to come up with a list of all the things that the president shouldn't be able to do. But I am troubled that while it is a norm that there wouldn't be that interaction, that people have kind of gotten beaten down, and it's been normalized that you would have. And so while those of us who are in this world would still be shocked by that conduct, I worry that the general public, some folks don't think it's all that out of bounds for the president. I mean, he's the president, that's part of the executive branch. Why can't he tell them who to prosecute? And so all of this is more in identifying that this is a really thorny, difficult thing that I don't think has an easy answer with a regulation. But I do know that there has to be more life breathed into the norm. And I think that comes partly from people on both sides of the aisle reacting more vociferously when it does happen, to be able to remind everyone this is not the way the rule of law works, so that we don't then just normalize all of this, and not just for a potential Trump presidency, but others to come.
Right, and maybe speaking up by what they call charismatic dissenters. In other words, people within your party where it's in your political disadvantage to speak up, but you do speak up anyway. Judge, since that's what you did.
So John, you scared me there. So
sorry, you're at the end of the table.
Let me gather my thoughts.
Sorry.
In what lawyers call an excited utterance, which is admissible for its own sake, despite its otherwise unreliability. I have to tell this story first. As I look down the barrel of this 20-foot conference table at a prominent member of the mainstream media, I will confess I was intimidated yesterday by the fact that you were of the mainstream media, and I thought I acquitted myself pretty well, and I thought I would acquit myself well today again, until you had us turn around and look at Bob Bauer, who was not on the screen. Rather, it was you.
There's nothing I like more, Judge, than me on a screen.
Well, and there's nothing I like less than you on the screen.
Well, with that, you share the view of my family.
A colleague of yours in the mainstream media came up to me at breakfast this morning and accosted me in the words of Republicans. Actually, all he did was introduce himself and thank me for what I had done. And at the end of the conversation, he said he allowed that, gosh, I speak faster in real life than I do on television. To which I allowed to him that the reason for that is that I try not to speak any faster than my mind can think, and that he ought to try that occasionally himself. So to get more serious, not serious, but more serious, so I'm going to return to a theme that I struck yesterday in the panel, albeit I'm going to do it sub silentio today without uttering the name that shall not be named, and say in as erudite a way as I can manage in the moment that in rotating over the executive power, we ought not over-rotate in response to the former president. The framers of our Constitution were pretty smart people, and they were prescient, if nothing else, and prescient about the powers of our tripartite government. They were focused even primarily on the powers of the executive, and they were skeptical. But they wrote a constitution that very deliberately did not attempt to articulate the outer boundaries or limits of the executive power in particular, or for that matter, the congressional power, though by default of the legislative power, those outer limits were defined more than for the president, as they were for the judiciary. But the point for us today is that they very deliberately did not attempt to articulate the outer limits of the executive power, and that was to preserve for all time what I have referred to as a constitutional tension. That is, by design, a constitutional tension always between the executive and the Congress of the United States. No more so was that intended than in the so-called emergency powers or extraordinary powers. And of course, that's what has played out for 250 years, to my lights, quite beautifully. That's not to say that there are not tensions in the moment of crises, but the framers intended those moments to be resolved between and with the executive and the Congress. And so from the Department of Justice standpoint, take any crisis, or any assertion of executive privilege over any matter at all, as Sally knows, our only responsibility is to negotiate that dispute out with Congress such that it never goes to court. And so and they never do go to court until the name who shall not be spoken, right? So this was all by constitutional design, and it's worked famously well until the prior administration. And Donald Trump push the constitutional envelope of his executive powers under the Constitution, not just to the limit, but beyond the limit. And so I think I'll stop by just saying our first order of business, and we've been about this now for 3 years, frankly, is to address the abuse of the executive powers. The abuse says that were undertaken by the former president, up to and including accountability for January 6th and the efforts to overturn the election. We have to do that, then return to business as usual about addressing the arguable disparities in the power structure. So I think I said I would end with that, but I will still instead end with the fact that that I hang on every word that Bob Bauer and Jack Goldsmith say and write. I think I reviewed their book when it came out, and I agreed with everything they said. But I also do what I'm told, and I read the essay for this thing, and what I took away from it was their distinction between, and I hope it's their distinction, between accountability for versus accounting for. So at least in that short essay by whoever wrote it, they were focused more on transparency, and with the thought that with transparency will come informed resolution of the dispute between the Congress and the executive, but also an informed electorate as to the disputes between the executive and the Congress.
Thank you, Judge. And I'll give Bob a chance to weigh in again and get more screen time for myself in a moment. But Andy's going to weigh in here at the end. Eddie, I want to ask you about impeachment, but take this in any direction you want. It seems to me that we've talked about norms and who maintains them, and the impeachment power for a president who makes himself obnoxious is a definition that's quite in the normie land. Mm-hmm. It's not in, there's no rule. And so this is driven by politics. And, you know, even the rule of law is up for grabs when you have a party that gets behind a leading figure who says, don't listen to this judge, that's an Obama judge, don't listen to this jury, don't listen to this part of the system and that. Once you carve it away, there's just just thin little bits left. So take that anywhere you want to take it.
Yeah, well, thank you. And I'm glad you asked a question I'm actually prepared to answer. I think in a crazy moment, this close to the end of the conference, actually, answering the question seemed like a nice change of pace. So the text really here is George Mason at the Constitutional Convention, right? Shall any man be above justice? And the members of the convention grappled with that, of course. The answer was no, but how to do that and how to provide a mechanism for that was, of course, a difficult question. And the notion of impeachment and removal, which I have to remind my students are separate procedures, of course, which becomes important over time. Can that process work to rein in executive overreach? Judge Lennox just put it nicely, the outer limits of the executive power, right? How do you police that boundary? Of course, they came up with treason, bribery, high crimes and misdemeanors, and then famously in Federal 65, Alexander Hamilton talks about the vague parts of that, high crimes and misdemeanors, as being, crimes that are political, relating to injuries done chiefly against society itself, the violation of some public trust. So at least in principle, separate from the criminal statute book, separate from something that's justiciable crimes. And of course, as members of Congress tried to figure this out, Gerald Ford famously said that an impeachable offense is whatever a majority of the House of Representatives considers it to be at a given moment in history, which is both true and a little trivializing. And it does lead to a worry, really that Hamilton himself had in Federal 65, where he talks about impeachment likely to connect itself with the pre-existing factions. It will enlist all their animosities, partialities, influence, and interest on one side or the other, and thus will be decided by the comparative strength of the parties rather than innocence or guilt. Jefferson, a few years later, wrote that the most formidable weapon for the purpose of a dominant faction that was ever invented is impeachment. So the worry, of course, becomes that impeachment is a partisan exercise, that its vagaries are interpreted in the favor of that dominant faction, of a partisan faction. This was something that President Trump tweeted about on Christmas Day, 2019. Actually, you may remember, why should crazy Nancy Pelosi, just because she has a slight majority in the House, be allowed to impeach the President of the United States? And of course, the answer is, well, the Constitution allows that. Whether it's a good idea or not is a continuing question. I guess the good news is that I think over time people have taken impeachment seriously. Right? It has been something that has risen to the level of serious debate over time. Congress has, I think, to avoid this whole high crimes and misdemeanor mystery, often sought to find an offense in the statute book, perjury, obstruction of justice, violating the Tenure of Office Act, right? We talked earlier about Andrew Johnson, but in the end, again, his rhetoric was not the main point of the trial. It was his violation of statute, whether, of course, that statute was constitutional, was a side issue. Even the Impoundment Control Act made an appearance, right, in the first Trump impeachment. The second impeachment is sort of a dramatic exception, right? There are clearly criminal laws at issue, and those are being dealt with in the court system now. But really, that was about a political crime. And yet, of course, he was not removed from office. He was not barred from holding future office, thanks to some, in part, some clever, if cynical, manipulations of the Senate calendar and the Senate procedure, but also, of course, because of partisan polarization. Even in that vote, the only vote to have a majority for conviction since Andrew Johnson's, again, 2/3 vote was not achieved. And so the worry is that what Jefferson and Hamilton foresaw comes to pass over time in a 50-50 nation, right? There is actually no dominant faction. And so in a weird way, it augurs the constant invocation of impeachment, but without any real way to make it a meaningful tool of accountability. And in fact, Jefferson, and this is the right place to quote Jefferson multiple times, he had decided by 1820 that impeachment was an impracticable thing, a mere scarecrow. So you wave it to scare the president, maybe, but it doesn't need always to be taken seriously. Now, I don't have a 10-point plan to sort of substitute for serious impeachment other than to say that people should be serious. I've been reminded over the last couple days of, I think it's the second to last episode of Succession. And I feel like saying to some of my elected representatives that, I'm a political scientist. I studied you for a long time. I love you, but you are not serious people. And unless they become serious, obviously, there's not, I've talked a lot about that already, not an immense attraction for making impeachment serious, because we come back to Gerald Ford's point. It's going to be what the House and ultimately the Senate want to do. I do think the transparency regime that Bob and Jack have talked about is very important. I think you need to know what the president's doing. You need to be able to get information, and the public needs that information before they select a president. I'm very much in favor of the kinds of reforms that Cy endorses to enhance congressional oversight of emergency powers. I think that makes sense. The long-term use of war powers or emergency powers, I think, do need affirmative congressional backing. There have been proposals to switch the default, right? So that instead of requiring a 2/3 veto override to actually end a presidential declaration or use of force under the war powers resolution, that those should expire and have to be, again, affirmed by a positive vote of Congress. I do think it would be helpful to look back over sort of leftover authority, statutes that are lying around, what was the phrase in Korematsu, like a loaded gun. The Insurrection Act has been mentioned, the DPA. I would add the Public Health Service Act from 1943, which was used a lot during the COVID crisis, in good ways, arguably, and perhaps bad, when Title 42, the entire part of the codes of the United States becomes shorthand for immigration, not reform, but truncation, that strikes me as a possible problem. So in short, I guess I want to go to Charles Black, who in 1974 said that Congress is by no means in a position of having to sit idly by until time comes to sharpen the impeachment spear. Right? There are lots of things Congress can do. We've talked for 2 days now about why they don't do some of these things, but again, you could do real and not show oversight. You could investigate. Doug Kreiner, colleague at Cornell, has written a lot about the power of investigation, actually, to shape opinion and to find fact. Can obviously use the power of the purse, can create commissions that do worthwhile investigations, say the 9/11 Commission. It could legislate in more specific terms, which would get away from some of the arguments over delegation that we've been falling into. I would actually like to see more capacity for its own sake. I take Phil's point that Congress will often pass what the president proposes in a given emergency. I'd like Congress to be able to actually vet that proposal, to be able to tell this is actually kind of a crappy piece of legislation, to be able to develop its own, perhaps. I mean, again, this is perhaps not quite wishful thinking. I do think there have been some useful efforts. Congressman Payne talked about the Modernization Committee. Phil Wallach over at AEI has written some, I think, useful things about Congress. Kevin Kosar, his colleague there as well. There's a Princeton set of working groups on congressional capacity that are moving forward. So there are some chances, I think. It doesn't just have to be more bourbon in the old sort of 50s and 60s cliche that everybody would get together and solve the problem by drinking some bad liquor. I'm all for more liquor, but it's not necessarily the entire solution here. So again, just to add a couple things that have been brought up, I think if impeachment does wind up being reserved then for political crimes, that leaves a lot of possible criminal crimes that need to be dealt with, and they're going to have to be dealt with really in the courts and in the judicial system, as well as, though, in the executive branch. This comes back to the question of DOJ independence. How to make that happen. We're seeing right now, right, the possibility of criminal trials being consumed by faction, but at least there we have a former president, I think little question, despite his own lawyer's contention that there's any kind of immunity there from criminal prosecution. I would like to raise the question for this audience, and certainly for the former acting attorney general, about whether the Department of Justice mandate that a sitting president cannot be indicted for a crime should be revisited. At least 2 independent counsels have thought that was bad legal doctrine. I asked the question. And then that circles back to judicial legitimacy, which has come up a couple of times. If courts are making decisions ranging from everything about statutory interpretation in terms of executive action, all the way again to possible criminal actions by presidents, whether they're culpable, the notion of clarity, trust, legitimacy, the Barbara Perry's paper raised, Bob, I think Cerati raised earlier as well. That becomes crucial. I mean, at the present moment, we seem to live in a land where the same words in a federal statute mean something quite different if you're in a district court in Texas rather than a district court in San Francisco. That seems hard to maintain, and yes, it moves up the system. But that strikes me as an issue as well. So anyway, wanted to tee up some of those points for further discussion and hope for serious people to grapple with them.
Excellent. We have about 15 minutes or so. Sally, I'd like to hear what your thoughts are on that. Let me go first to Bob, though, since you're in the distant place and I can't see you nodding. If you want to say something, if you wanted to add anything, and meanwhile, the rest of you at the table and those of you in the back benches, if you have a remark or something that's been sparked by this, just give me a nod and we'll carry out our last 15 minutes. Bob, any last thoughts?
He says, just one quick thought about the question of when it is a good time, not a good time to consider these issues. I think earlier a comment was made, a perfectly reasonable comment was made that, maybe right now on the precipice of all these national security potential emergencies, actual emergencies, anticipated emergencies, it would not be in the nation's interest to engage in any activity to constrain presidential emergency power. I can't say that I agree with it. I want to think about that some more, but it seems to me that given the United States' definition of its role in the world, which is, obviously an expansive definition, and all throughout my lifetime has meant that we have been on the precipice over any number of years of really, really significant national security crises or emergencies. I think that would mean that this is a debate that would be just simply too long deferred. And there are responsible actions that we can take, in my view, that would not ultimately hamper the president's ability to respond to real emergencies. So I worry about any given moment being cited as a bad time to do something because it takes so long to get it done. And in the period of time that we wait, or during the period of time immediately after one emergency that we think the moment has come, interest will wane, and soon there'll be another emergency upon us. And the only other comment I wanted to make very quickly is I'm second to none, as you can tell from the title of our book and the basic thrust of the book that I wrote with Jack Goldsmith. I'm second to none in my profound concern over how Donald Trump thought about the presidency, choice of verb in dispute, and acted while president. But I do think we need to look back over the expanse of American history and recognize that the ground was in many ways made very fertile for that kind of abuse. Presidents before him, in circumstances where they were more experienced and knew better, took actions that were very questionable, actions that were, if you will, maybe not quite autocratic in character, but heedless of the question of how best to define the boundaries of presidential authority, when to bring Congress into those conversations. I'm thinking, for example, of Jack Kennedy's performance during the Cuban Missile Crisis, which was widely lauded at the time, in many respects very effective. But when he brought Congress in after days and days of deliberation within the administration about how to respond to the Russian missile emplacement in Cuba, some members of Congress expressed a view about what might be done, and he told them, it's none of your business. It's up to me. And so I raised the question of when the right time is, and I think it's probably, depending on the responsibility of the action taken, just about any time.
Sally.
Thank you. Anyway, I really enjoyed the conversation.
Thank you, Bob. Sally, your thoughts on whether a sitting president can be indicted?
I'm going to answer the question I think was actually asked,
okay.
and that was, should OLC revisit the issue, right? Right. I will confess, I have not studied the OLC opinion closely enough to opine now as to what my personal view on that is. But I do think that the notion that a sitting president can't be indicted has confounded enough people to where it is worth the Department of Justice looking at it again. The issue is when. I mean, if you were to do that, on the precipice of actually indicting the president, then that decision doesn't appear to have legitimacy because it looks like you're just reversing the DOJ prior guidance to be able to go after whoever this guy is. It's also kind of weird, though, for OLC to revisit an opinion or issue an opinion when there's not an issue on the table. So I get your point, and that opinion and that directive has certainly perplexed people and also sort of undermined this idea that no one is above the law. So I understand that, but I will confess I haven't studied the opinion closely enough to really have a view, although I bet there are people in this room who have.
Yes.
So that's, yeah.
I don't want to jump around because I'm not going to, it's not on this point, but it's on what Bob just said just
Grab it, and
before.
I don't think somebody will be shy if they'd like to revisit
Okay.
Sally's.
Thanks. I will preface it by saying I am not the child of divorce, and I still want to find the in-between ground between what Bob was saying and what Eric said. And to me, it's there because I think that the very good arguments that Bob and Jack Goldsmith made about, that also seem to me very practical on the transparency side, on putting sunshine on things, which in itself can lead to accountability. I think there's a solution set there that doesn't implicate what I agree with Eric are very real concerns about unintended consequences in terms of constraining a president. And I very much worry about any of the time clock measures on legislation, having lived through that on, again, both ends of Pennsylvania Avenue, those are rife for unintended consequences. They sound great when people pass them. And then what happens, let's say you put a time clock on, and I don't know, hypothetically, your House can't elect a speaker. And that precludes you from being able to take the action that the majority of people agree is in the national security interest of the United States. But I think in the transparency space, you could get stuff done that fulfills what I think, again, all legislators should have to take as the Hippocratic Oath of do no harm as a starting place. And I think you could concurrently execute in a variety of ways a review of existing legislation on the books for a variety of purposes. I think some of it can be reused. I think Defense Production Act probably has enhanced utility in a variety of ways. Maybe it needs amendment, maybe not. But you could do a review of everything that's out there for what's working and what's not. So that ideally then you work with a problem solvers caucus equivalent for a future Congress on how you address those things. And you've got the transparency stuff going in the meanwhile, but you're trying to ensure you're doing nothing that does harm at the same time.
Maybe that clock could be working days, not just days, but working days in Congress. That would
Define working days.
Yes. Yes, please, sir.
So would this be the appropriate moment for me to reclaim my time to,
Yes.
to deal with it?
Yes, the gentleman is recognized.
So the term deep state, dedim devlet in Turkish, is an importation into American political discourse from Turkey. And it derives from the Kamala system put in place by Ataturk, who Lord Kinross, his biographer said, accomplished a liberal end with very illiberal means. And he left, unresolved the question of what's the military's role in politics, what's the role of ethnicity in the nation, what's the role of religion in society, and what's the role of the state in the economy. And when Turkey moved to multi-party politics in 1950, there was a sense that there was a group in the military, the intelligence services, the judiciary, in some cases organized crime, that were conspiring among each other to maintain the secular Kemalist system and repressing the Kurds and repressing pious Muslims, et cetera. To paraphrase the late Lloyd Benson, I've been ambassador to a country that arguably had a deep state. I think I can recognize the deep state when I see it. And the United States of America does not have a conspiratorial deep state. And we shouldn't, to Sarah's point, confuse it with the administrative state we do have. I yield back.
Yes, all right. Yes.
Yes.
We are almost on time, but if any in the galleries, Phil, I wanted to ask you a question just in our last seconds here. You mentioned that Congress is good after the fact. How could Congress be better before the fact? Or is that not their role?
Oh, actually, of course they could be better before the fact. And what they could do, for instance, is say, what are the emergencies that we're really worried about, and what are the operational capabilities we'll want to have on hand if this happens? And what do we need to do to put that in place? So I'll give you actually an example of a partial success story out of the COVID context. So you remember the anthrax scare in 2001, but there was some abiding concern about biological hazards. And then famously, President Bush read a book about the pandemic of 1918, which his aides would later refer to as the $7 billion book by a man named John Barry. And what happened then is Bush went to Congress and said, we actually need to do a lot of things to get ready for a possible enormous biological event. And Congress then passed legislation to do that. And actually, everyone involved, by the way, in that era looks back on it nostalgically, is that there was actually a period of relatively high preparedness for a public health emergency that's generally dated between, circa 2005 to about 2015 or so. And then things began to just kind of lapse and fade and dissipate. And and kind of disappear. But that was actually a case where the president and Congress moved together proactively to stockpile things, create new administrative capacities, and so on, for a danger that they were aware of that hadn't happened yet. So this is not some unrealistic utopian ideal. It can happen. There are examples where it's happened. Maybe others can think of additional ones. But then to contrast that, say, with the legislative response to the COVID crisis. I was involved in a lot of discussions about should we have a national COVID commission. And I'll just tell you, frankly, that neither party wanted to have any legislative agenda addressing the lessons learned from the largest health crisis to hit the country in our lifetime. Neither party wanted to fundamentally change the capabilities of the country to meet another such health emergency. I can go into a lot of detail about the politics of that issue in both the Democratic Party and the Republican Party, and why they didn't really. Of course, the only reason you create a national COVID commission is to help it drive legislation. They didn't want to create the commission because they didn't want to drive legislation. That's true of the Biden administration as well as the Republican side. That was a political calculation made at the top of the Biden administration, not just a policy calculation. So that's an example where here's one case in the early 2000s where we moved proactively and did good. And then another case where we've experienced a horrific emergency and have basically done nothing structurally to learn from it.
I believe Fran was the one who was in the line of sight when the president came back from that weekend where he'd read John Barry's book.
Yeah, and I would just, Philip is correct. Look, that is a positive example of being proactive. That was driven personally by the President of the United States. That was not staff, that was the President. And when asked why, his response was, yes, it's the 100-year event. We saw Katrina, that was the other 100-year event. We're not going to have another 100-year event we're not prepared for. And he drove that out of the Oval Office. I would remind folks, however, having taken that on proactively, those of us who were directly involved were the subject of late-night comedy and criticism from the mainstream media that we were dreaming up things, problems to worry about that didn't exist. And so you want to do this, it is good governance, but you also have to have sort of the public will to support that kind of good governance. And it sort of takes us back to conversations earlier in these 2 days where people just don't know, and they don't know what they don't know what to worry about. And so it's hard to build that sort of public support for that kind of proactive approach.
By the way, it is worth just noticing, even though the preparedness lapsed and went way down, had that structure not been built in the early 2000s, the general response, including the rate of vaccine development, would actually have been much worse, and easily on a worldwide basis, another 1 million people die, more. So that's actually a case where the work that was done 20 years ago was not futile. It just turned out to be people kind of let things pass, and it wasn't as ready as it needed to be.
And Fran, on behalf of the mainstream media, I'm sorry you got accused of dreaming up things. That's usually our job. Are there any other last? Oh, yes, indeed, sir.
Really quickly, Phil's comment about the failures of politics to deal with our most recent COVID crisis reminds me of Josh's excellent point with which I very much agree this morning about the significance of the private sector in caring for the good of the American people. And perhaps, although FDA certainly had something to do with the speed of pharmaceutical company innovation, perhaps through lessons learned from what we went through not being ready, we can improve the circumstance, the preparedness for something in the future. But I think the private sector really stepped in a way that perhaps government failed us.
Bill, I hand it over to you. Unless, yeah.
Well, thank you, and thanks to everybody. I want to start by thanking our team. it happens to be Christina's birthday. I think you, by the quality and the spirit of the conversations, I think you've given her a birthday present that she's worked very hard in the last year to earn. So, and that goes to the rest of our team. You know, there are two guys upstairs and Sheila, who keeps pushing, clicking a mouse on your faces when you speak so that your name can show up on the screen. Rob at the soundboard, June and Reed and Kelly and Camille, who have helped greet you and escort you in, Andrew and Nancy and Jen, who have been will be processing the receipts to reimburse you for your travel. Alfred, who has been scheduling your hotels and cars and the like. Lindsay, who helps manage all of this, and Howard and the communications team, who will help us synthesize this and start to do a little bit of public promotion to our friends watching out there in video land. You were not the most important audience, but you were an important audience. The people we saw yesterday, people tended to stick with about 3.5 hours of yesterday's 4.5 hours of conversation. I see the glass is more than half full there. And to you all for staying with us for 2 days. There were people coming in and out, but for those of you who have been with us, particularly for the 2 days, we're so appreciative. There is one more event this evening. Judy is going to moderate a discussion in the Paramount that's going to include, let's see, Laura, Mike Emanuel, and no, Peter's unfortunately had to stay in D.C. Our colleague from the Atlantic, Elena from the Atlantic. So we hope you will attend that. That starts at 5 o'clock. But even if you don't, we really thank you all, particularly our moderators. You all stepped in, kept the conversation moving, kept us laughing. And even if you didn't have the gavel, you wielded the gavel. As another UVA graduate, I think of Pete Seeger. If I had a hammer, I'd get hammered in the morning, I'd get hammered in the evening, all over this land. But with that, I get to gavel us to a close and thank you all.